Welcome to EU Privacy for All, Session 10 on the published GDPR, Article 25 on privacy by design and by default. The Article 23 debated during trilogue negotiations was finally renumbered Article 25 on data protection by design and by default. It lays down that, taking into account the state of the art and the cost of implementation and the nature, scope, context and purposes of the processing, as well as the risks of varying likelihood and severity for rights and freedoms of natural persons posed by the processing, the controller shall, both at the time of the determination of the means for processing and at the time of the processing itself, implement appropriate technical and organizational measures, such as pseudonymization, data minimization, in an effective manner and to integrate the necessary safeguards into the processing in order to meet the requirements of the regulation and protect the rights of data subjects. It also stresses that, by default, the controller shall implement appropriate technical and organizational measures for ensuring that only the personal data which are necessary for each specific purpose of the processing will be processed. That obligation applies to the amount of personal data collected and not only data used. In particular, such measures shall ensure that by default, personal data are not made accessible without the individual's intervention to an indefinite number of natural persons. An approved certification mechanism could be used as an element to demonstrate compliance. Two recitals refer to principles of data protection by design and by default. Recital 78, stressing that internal policies could usefully refer to such principles, and Recital 108, laying down that in the absence of an adequacy decision, the controller or processor should take measures to compensate for the lack of data protection in a third country, referring in particular to compliance with general principles such as the one of data protection by design and by default. Article 47 on binding corporate rules also refers to the necessity to specify in the BCR that the application of the general data protection principles such as data protection by design and by default, will be done. The Directive in Recital 46 refers to the protection of the rights and freedoms of data subjects with regard to the processing of personal data, requiring that appropriate technical and organizational measures would be taken both at the time of the design of the processing system and at the time of the processing itself. What should accountable data controllers and processors get prepared for? First, they should put in place privacy by design, that is to say, implement the set of appropriate technical and organizational measures that will guarantee that data protection is ensured at each step of the processing. That is to say, at the time of the determination of the means for processing, using pseudonymization, data minimization, and additional safeguards, depending on the state of the art, the cost, nature, scope, context, and purposes of the processing, and the risks for rights and freedoms of individuals. But also implementing, at the time of the processing itself, appropriate technical and organizational measures. They will also have, by default, the obligation to process only personal data which are necessary for each specific purpose of the processing. They will not have any margin of maneuver to make data broadly accessible without individuals' intervention. They will have to be using approved certification mechanism and internal policies monitoring those technical and organizational measures. So the question raised by such a provision is knowing more about the state of the art and the cost notions. Will risks assessment be a way to better frame privacy by design and by default, or should we wait for EDPB more specific guidance?